The property of the husband often passes to the wife upon his death, and the property of the wife passes to the husband on the wife's death. So what happens if they die simultaneously in a car accident, plane crash, or some other lethal event? Well, if it cannot be established by clear and convincing evidence that one survived the other, community property and quasi-community property held by husband and wife is divided in half. Half goes to the husband and half goes to the wife. The husband's half is treated as if the husband survived the wife. The wife's half is treated as if the wife survived the husband. In the case of a joint tenancy, when one joint tenant dies, the property goes to the other joint tenant. So simultaneous death of joint tenants creates an issue for the courts to resolve. Simultaneous death of joint tenants is treated in a similar way to simultaneous death of husband and wife. This makes sense as community property held by husband and wife has many characteristics of joint tenancy. The property held in joint tenancy is divided. Half is treated as if the first joint tenant survived, and half is treated as if the second joint tenant survived. The rule is somewhat different for beneficiaries of a trust or insurance policy that involves property passing from the deceased to the beneficiary on death. If the beneficiary dies at the same time, the policy or trust has no beneficiary, and this is how these situations are treated. She is deemed not to have survived, and the deceased beneficiary does not take under the trust or insurance policy. In some situations, it's not clear whether two individuals died at the same time, or whether one person survived the other by a matter of minutes, hours, or days. These cases are treated as simultaneous death when it cannot be established by clear and convincing evidence that one survived the other.